Welcome to our Rotherham Sendias video about permanent exclusions. This video has a particular interest in an independent review. All the details that are within this video you will find within the statutory guidance, and the link for the statutory guidance around school exclusions is on the top of this slide. What this means is the information within this video is relevant if your child has been excluded from a maintained school, an academy, or a pupil referral unit. This workshop is relevant if your child has been permanently excluded, if the governing board has met, and following their decision you wish to request an independent review. So what is an independent review panel? An independent review panel supports a robust process of scrutiny to ensure that exclusions are lawful, reasonable, and procedurally fair. The role of the panel is to review the governing board's decision not to reinstate a permanently excluded pupil. In reviewing the decision, the panel must consider the interests and circumstances of the permanently excluded pupil, including the circumstances in which the pupil was permanently excluded. But they must also have regard to the interest of other pupils and people working at the school too. The panel must apply the civil standard of proof. So that is, for example, on the balance of probabilities, which means that it's more likely than not that a fact is true. This should be applied rather than the criminal standard of proof, which is beyond reasonable doubt. The independent review should be conducted in an accessible, unthreatening, and non-adversarial manner. Some things for you to consider before you request an independent review panel meets. The independent review is not an appeal about the head teacher's decision to permanently exclude your child. They can't overturn the head teacher's original decision. They are there to review the governing board's process and their decision making. Following the review, the panel can decide to either uphold the governing board's decision that they made not to reinstate your child. They can either recommend that the governing board reconsiders reinstatement, or they can quash the governing board's decision and direct that the governing board reconsiders reinstatement. So when can you apply for an independent review to happen? The legal timeframe for an application for an independent review is within 15 school days of the governing board's decision not to reinstate a permanently excluded pupil. Or, if you've lodged a disability discrimination claim under the Equality Act in relation to a permanent exclusion, you can apply for an independent review within 15 school days of the final outcome of the appeal. Any application made outside of the legal timeframe must be rejected by either the local authority or the Academy Trust. If you apply for an independent review within the legal timeframe, the local authority, or if it's an academy, it will be the Academy Trust, must at their own expense arrange for an independent review hearing to review the decision of the governing board. The review must begin within 15 school days from the parent's application of a review, and the trust or local authority must make reasonable steps to identify a date for the review that all parties are able to attend. It is possible to request a remote independent review, but where a parent does not request a remote meeting or does not state a wish either way, arranging authorities, so either the local authority or the trust, must hold the meeting in person, unless it's not reasonably practicable to do so. If it's not reasonably practical, then the reasons must relate to extraordinary events or unforeseen circumstances, such as unforeseen school closure due to floods, fire, or outbreak of infectious illness or disease. So if a meeting goes ahead in person, where will it take place? The local authority or the Academy Trust must arrange a venue for the hearing to take place. Whatever the venue, the panel must hold the hearing in private unless the local authority or Academy Trust directs otherwise. The venue must be reasonably accessible to all parties, and the local authority or Academy Trust should try to ensure there's sufficient room for the parties to wait separately if possible. There are rules about who panel members can be on an independent review. The panel must consist of either 3 or 5 different members, and this must include the following types of people. So a lay member to chair the panel who's not worked in any school in a paid capacity, but this disregards any experience as a school governor or volunteer. A current or former school governor of a maintained school, or member of a pupil referral unit management committee and directors of academy trusts who have served as a governor for at least 12 consecutive months in the last 5 years, provided that they have not been teachers or head teachers during that time. There must also be a head teacher or individuals who have been a head teacher within the last 5 years. The local authority or academy trust may also appoint a clerk to provide advice to the panel and the parties on procedure, law and statutory guidance for suspensions and permanent exclusions. The clerk, however, should not have served as the clerk to the original governing board where the decision was made not to reinstate the pupil in the first place. There are also rules around who the panel shouldn't consist of. So there shouldn't be a member of the local authority if the excluding school is a maintained school or pupil referral unit. There shouldn't be a director of the academy trust of the school if the excluding school is an academy. There shouldn't be the head teacher of the school who has permanently excluded the pupil, or anyone who has held this position in the last 5 years. There shouldn't be an employee of the local authority or academy trust or the governing board of the school who has permanently excluded the pupil, unless they are employed as a head teacher at another school. Anyone who has, or at any time have had, any connection with the school, the local authority, the academy trust, the governing board, parents or pupil, or any connection with the incident leading to the permanent exclusion which might reasonably be taken to raise doubt about their impartiality. Although an individual must not be taken to have such a connection simply because they are employed by the local authority or academy trust as a head teacher at another school. All panel members should have also had the relevant training within the last 2 years. Panel members should declare any conflict of interest at the earliest opportunity. Where a clerk has been appointed, or if they haven't been appointed, then the local authority or academy trust have to inform the following people that they are entitled to make written and oral representations to the panel, attend the hearing, and also be represented. Please remember that parents or the young person can ask to bring a friend or a supporter. They must inform the parents or the pupil if they're over 18, the head teacher, the governing board, and the local authority in the case of a maintained school or pupil referral unit. The clerk must make reasonable efforts to circulate to all parties copies of relevant papers at least 5 school days before the review, and these papers must include the governing board's original decision, the parents' application for the independent review, and any policies or documents that the governing board was required to have regard to in making its original decision. They should give all parties details of those attending and their role once the position is clear, and they should attend the review and ensure that minutes are produced following instructions from the panel. We often get asked if your child should attend the independent review panel. Where a permanently excluded pupil is attending the hearing, consideration should be given in advance as to the steps that will be taken to support their participation. If the permanently excluded pupil is not going to attend the independent review panel, it should be made clear that they may feed their views through a representative or by submitting a written statement themselves. So what can you expect at the independent review panel? The panel will generally need to hear from those involved in the incident or incidents leading to the permanent exclusion. If there's an alleged victim, they may wish to be given a voice at the review too. This could be in person, through a representative, or by submitting a written statement. In the case of any witnesses who are pupils of the school, it will normally be more appropriate for the panel to rely on written statements. However, pupils may appear as witnesses if they do so voluntarily, and if they are under 18, they should have their parents' consent. In such cases, that pupil's parents should also be invited to attend the meeting in support of their own child. Where character witnesses are proposed, the clerk should seek the agreement of the panel, but this should be allowed unless there's good reason to refuse it. All written witness statements should be attributed, signed and dated unless the school has good reason to wish to protect the anonymity of any witnesses, in which case the statement should at least be dated and labelled in a way that allows it to be distinguished from the other statements. If any party has brought a representative, they may also make written or oral representations to the panel. In addition to written statements, any written evidence from the school should also be circulated in advance of the meeting. such as policies and documents of the school which the governing board would reasonably have been expected to take account of in reaching its decision on reinstatement. Where the school's case rests largely or solely on physical evidence, and where the facts are still in dispute, then the physical evidence, if practicable, should be retained and available to the panel. Where there's difficulties in retaining physical evidence, photographs or signed witness statements should be used instead. New evidence may be presented to the panel, though the school may not introduce any new reasons for the permanent exclusion. As part of an independent review panel, you can ask as a parent for an SEN expert to be present. If your child has special educational needs or a disability, then you may wish to request an SEN expert attends the independent review panel too. If requested by the parents with your original application for the independent review, the local authority or academy trust must appoint an SEN expert to attend the review and must cover the associated costs of this appointment. The parent or a pupil, if they're over the age of 18, have a right to request the attendance of an SEN expert at a review, regardless of whether the school recognises that their child has SEN. Where an SEN expert has been requested but isn't actually present at the independent review panel, the panel should make parents aware of their right to request that the review is adjourned until an SEN expert can attend. So what's the role of an SEN expert and why would you ask for one? The SEN expert's role is similar to an expert witness, providing impartial specialist advice to the panel on how SEN might be relevant to the permanent exclusion. The SEN expert should base their advice on the evidence provided to the panel, and their role does not include making an assessment of the pupil's special educational needs. The focus of the SEN expert's advice should be on whether the school's policy, which relates to SEN, or the application of these policies in relation to the permanent excluded pupil were lawful, reasonable, and procedurally fair. If the SEN expert believes this was not the case, they should, where possible, advise the panel on the possible contribution this could have made to the circumstances of the pupil's permanent exclusion. Where the school doesn't recognise a pupil as having SEN, the SEN expert should advise the panel on whether they believe the school acted in a legal, reasonable and procedurally fair way with respect to the identification of SEN that the pupil may potentially have, and any contribution that this could have made to the circumstances of the pupil's permanent exclusion. The SEN expert should not criticise a school's policies or actions simply because they believe a different approach should have been followed, or because another school might have taken a different approach. So who could be appointed as an SEN expert? A person should not be an SEN expert if they have, or at any time have had, any connection with the local authority, the academy trust, the school, the parents or the pupil, or the incident leading to the permanent exclusion, which might raise doubts as their ability to act impartially. They must be someone who has an expertise and experience of special educational needs considered by the local authority and the academy trust. The SEN expert should be a professional with first-hand experience in the assessment and support of SEN, as well as an understanding of the legal requirements on schools concerning SEN and disability. So examples of suitable individuals might include educational psychologists, specialist SEN teachers, SENCOs and behaviour support teachers. The SEN expert should not have had any previous involvement in the assessment or the support of the SEN for the permanently excluded pupil, or their siblings of the permanently excluded pupil. So what outcomes can come from the independent review panel? The panel's decision does not have to be unanimous and can be decided by a majority vote. In the case of a tied vote, the chair has the casting vote. The panel may only quash a governing board's decision not to reinstate if it considers that the decision was flawed when considering in the light of principles applicable to an application for judicial review. In deciding whether the governing board's decision was flawed and whether to quash the decision not to reinstate, the panel must only take account of the evidence that was available to the governing board at the time of making its decision not to reinstate. This also includes any evidence that the panel considers would or should have been available to the governing board and that it ought to have considered if it had been acting reasonably. If evidence is presented that the panel considers is unreasonable to expect the governing board to have been aware of at the time of its decision, the panel can take account of the evidence when deciding whether to recommend that a governing board's original decision is reconsidered for reinstatement. The panel should ask everyone apart from the clerk to withdraw before the panel makes a decision, and the clerk may stay to help the panel by referring to the notes of the meeting and providing advice on the wording of the decision letter. What the independent review panel has to consider when making a decision. When considering the governing board's decision, the panel should apply the following tests. First of all, illegality. Did the governing board act outside the scope of its legal powers in deciding that the pupil should not be reinstated? Irrationality. Did the governing board rely on irrelevant points, fail to take account of all relevant points, or make a decision so unreasonable that no governing board acting reasonably in such circumstances could have made it? Or was there procedural impropriety? Was the governing board's consideration of procedurally unfair or flawed that justice was clearly not done? Following the review, the panel must issue written notification to all parties without delay. This notification must include the panel's decision and the reasons for it. Where relevant, details of any financial readjustment or payment to be made to the local authority if a governing board does not subsequently decide to offer to reinstate a pupil within 10 school days. And any information that the panel has directed the governing board to be placed on the pupil's educational record. The independent review panel decision is binding on the pupil, the parents, the governing board, the head teacher, and the local authority. So here's some practical things to consider before applying for an independent review panel. Do you feel that there are things that need to be reviewed independently? For example, did the governing board have all the relevant information? Did they follow the procedure correctly, or were mistakes made that could have impacted on their decision making? If you're requesting an independent review panel, remember the timescales to make the request. Do you feel the independent review process would benefit from an SEN expert? If so, add this to your request. Were all witness statements available, including your child's, for the original decision? Would you or your child benefit from the support at the independent review panel? If so, you may wish to secure this early and inform the clerk. Make notes of the things you wish to say or ask, and prepare a summary of what you wish for the independent review panel to consider. Ensure you are clear where the independent review panel is taking place, what time it's happening, and how you'll get there. And if you have any younger siblings to take care of, arrange alternative care for them to allow you to focus on the meeting. We hope you found the information within this video helpful. Thank you for taking the time to listen.